Monica, a notary public in New York who has never been admitted to practice law, engages in multiple questionable acts. She agrees to represent her neighbor in a criminal court proceeding even though she is not an attorney. Monica also prepares a complex trust instrument for the same neighbor and charges a substantial fee. Additionally, she issues a false certificate intentionally misstating the date on which a signer appeared before her to deceive a lender. Monica then forges a will, altering the testator's signature to change the distribution of property. Finally, Monica performs notarial acts without ever having taken or filed her required oath of office, believing this omission is merely a minor infraction, a violation rather than a misdemeanor. Which of the following statements are accurate under the laws provided? 1. Representing another person in a criminal proceeding without being admitted as an attorney constitutes an unauthorized practice of law. 2. Preparing a trust instrument for another person for a fee without being an attorney is unauthorized practice of law. 3. Issuing a false certificate with intent to defraud is a Class E felony. 4. Forging a will, an instrument affecting the disposition of property after death, is forgery in the second degree, a Class D felony. 5. Performing notarial acts without having taken and filed the required oath of office is merely a violation, not a misdemeanor. Let's have a look at each of these statements as compared to the requisite law to help us to determine the solution. Statement 1. Representing another person in a criminal proceeding without being admitted as an attorney constitutes unauthorized practice of law. If we have a look at the judiciary law section found in the Notary Public License Law Booklet entitled None But Attorneys to Practice in the State, and this is section 484, it states that no natural person shall ask or receive directly or indirectly compensation for appearing for a person other than himself as attorney in any court or before any magistrate, or for preparing deeds, mortgages, assignments, discharges, leases, or any other instruments affecting real estate, wills, codicils, or any other instrument affecting the disposition of property after death, etc. And that would also include a trust document that is such a legal instrument that can affect disposition of property, whether before or after death. And with that in mind, if we look at statement 1, representing another person in a criminal proceeding would fall under this section and would constitute an unauthorized practice of law. Therefore, we can put a check mark next to it as being accurate. Similarly, statement 2, in which it states that preparing a trust instrument for another person is also an unauthorized practice of law for a notary public who's not an attorney, is an accurate statement based on that same law. We can put a check mark next to number 2 as well. Statement 3 states, issuing a false certificate with intent to defraud is a Class E felony. If we have a look at section 175.40 of the Notary Public License Law Booklet entitled Issuing a False Certificate, it states that a person is guilty of issuing a false certificate when being a public servant authorized by law to make or issue official certificates or other official written instruments, and with intent to defraud, deceive, or injure another person, he issues such an instrument or makes the same with intent that it be issued knowing that it contains a false statement or false information. And the punishment for that is issuing a false certificate is a Class E felony. So statement 3, in stating that this is a Class E felony, is accurate based on that law, and we can put a check mark next to it as well. Statement 4, forging a will, an instrument affecting the disposition of property after death, is forgery in the second degree, a Class D felony. If we have a look at section 170.10 of the Notary Public License Law Booklet entitled Forgery in the Second Degree, it states a person is guilty of forgery in the second degree when with intent to defraud, deceive, or injure another, he falsely makes, completes, or alters a written instrument which is or purports to be or which is calculated to become or to represent, if completed, number 1, a deed, etc. So that's what the statement refers to, and that is forgery in the second degree, and it states forgery in the second degree is a Class D felony. So statement 4, in stating that this is a Class D felony, is accurate, and we can put a check mark next to it. And finally, statement 5, performing notarial acts without having taken and filed the required oath of office is merely a violation, not a misdemeanor. If we have a look at the Public Officers Law section of the Notary Public License Law Booklet, it states, a notary must not act before taking and filing oath of office. The Public Officers Law section 15 provides that a person who executes any of the functions of a public office without having taken and duly filed the required oath of office as prescribed by law is guilty of a misdemeanor. A notary public is a public officer. So statement 5, in stating that it's merely a violation, not a misdemeanor, is inaccurate, and we can put an X next to it. With all this in mind, let's have a look at the 4 choices to determine the solution. Choice A states 1, 2, and 3 only are accurate. That's incorrect because 1, 2, 3, and 4 are accurate. Therefore, choice A is not our solution. Choice B states 1, 2, 3, and 4 only. Well, this is correct based on having check marks next to 1, 2, 3, and 4 above, but not 5. But to be in the habit of looking at all 4 choices, let's have a look at choices C and D. Choice C states 1, 3, 4, and 5 only. This is incorrect because 5 is not accurate, whereas 2 also is an addition to 1, 3, and 4, and therefore choice C is not our solution. And finally, choice D states all of the above. Well, this is incorrect because 5 is actually not accurate, and therefore choice D is not our solution, which indeed leaves choice B, 1, 2, 3, and 4 only, as the correct solution.